That day he was condemned, or rather sentenced, in the whole of Biafran land, in the whole of Igbo land. I am a bishop, I'm around. It looks like somebody, like, it's like a dead, somebody died.
But people are jubilated. We saw all the videos and pictures
Not
on social
in Igbo
media.
land. It's like the day.
In the Southeast.
No, if I see anybody jubilation, it's political jubilation. I am telling you as a bishop, we are close to the people. It's like somebody died in Igbo land.
I think the court would have, for me, such a thing, the court would have made a pronouncement whether or not his right was violated based on the evidence before the court. Then the one of better health care, that one is something the court would have also made a pronouncement on if the merit was there. So the court would not have maybe look at the criminal conviction of Nnamdi Kanu in determining whether this issue is an academic exercise, because issue of rights does not the issue of right violation is not at the point when judgment is delivered. It's at the point the person alleged that the right is or her right has been violated. So I believe just we as lawyers, ours is to make our opinion, but whatever the judge says is what the law is. But that is why we also have the hierarchy level of the court, whereby you go to the Supreme Court. But for a court to say that an infringement of fundamental rights is an academic exercise, I think is not something that the Nigerian jurisprudence recognize, in my opinion. Obviously, the court wouldn't have said that, well, it's an academic exercise. The court would have looked at the merit of the case. So options available for Nnamdi Kanu now is for him to approach the Supreme Court. And I think maybe I won't say grammatical error, but I think is the wordings of the court towards dismissing the case. And I believe the Supreme Court would have made, will look at it and see if there is merit in his fundamental right infringement or not. So that is the remedy available for him, for his counsels or his counsel to take now.
You know, Kanu faces life for incitement, yet many who kidnapped and killed remain untouched, with facing no consequences. How do you explain this double standard? Well,
I have had a lot of conversation about Nnamdi Kanu's situation, including revealing to the Nigerian people that his trial was pre-planned. Everything that eventually played out on the day of his conviction had already been exposed by me on November 5. Maybe we are only lucky that we fought a bit through the Free Nnamdi Kanu protest to have saved Nnamdi Kanu from a hangman's noose. They were going to sentence him to death. That was the plan. And you can check my Twitter and Facebook posts on November 5, because I was giving that information in advance. They also, as a result of that, got very upset that we had a protest in Abuja. They shot at us, tear gas, arrested his lawyers, myself, later, and took us to the court outside of, within Abuja, but, near Kuje, and sent us to prison for 4 days. After we were granted bail on a Friday, the judge who was supposed to sign off on our bail paper ran away. He didn't come back until Monday. They were already setting the agenda for Nnamdi Kanu's conviction, or whatever they were going to do. But when they realized that maybe this is not popular or not going to be popular, they kind of pulled back a bit, and they did the life imprisonment. And they have also realized that even the life imprisonment has not stopped his life, or the life of what he stood for. Because it came at a time that, like I've always said, he prophetically predicted some of the things that are happening in Nigeria now. And when he was eventually convicted, those things have come full circle in terms of terrorism, the unchecked activities of the people you call terrorists or bandits, who have been given preferential treatments in Nigeria over time. They always have the right, they can drive around in their convoys with vehicles seized from the Nigerian army. One of them wore a uniform of a police commissioner, an assistant police commissioner he killed. He wore his uniform to town. They were carrying their magazines and their heavy-duty weapons and ammunition and addressing press conferences. I insist that till date, the only evidence that was adduced against Nnamdi Kanu in this trial, the whole trial, was that he had a microphone and he had a radio transmitter and his underwear, both top and bottom, that he found in a hotel. Every other evidence they claimed was against him were things that were circumstantial. Oh, he said that the people should kill police, even when he was not in the country. Oh, he was the one who made NSAS to become what it is. But there are celebrities in Nigeria who claim they started NSAS. I started NSAS in Abuja. And I was one who gathered a lot of people that joined NSAS by calling them individuals, some of the celebrities. So if those ones are being celebrated for doing NSAS, why is Nnamdi Kanu being sent to prison for life? Just for speaking on the day of NSAS to say, oh, do this or whatever they said he said. So everything they accuse him of are things that they had no evidence caused any problem that they adduced caused. They even accused him of killing Gulag while he was in detention. I know something about being in DSS detention. You have zero access to communication. Even if you smuggle something, and they have a way of monitoring you. So how could somebody like that be sentenced to death? And the terrorist from one of the Boko Haram commander was sentenced to 20 years in prison. That is why Nigeria is where it is today. Some people in our animal farm, some animals are superior to others. And until that is addressed, until the justice applies to everybody in Nigeria, you are not going to get peace without justice. That's what so many of us have been saying, whether you like to hear it or not. But I feel it has come full circle now, that even those who felt like they can bamboozle others by saying, oh yeah, he did this, he's a bad person, they are now dealing with the real bad people. Unfortunately though, those real bad people have cover. They have immunity.
So let's get back to Sowore in the house, please. Some say Southeast power brokers and not the presidency are the ones driving Kanu's continued detention. So how is this shaping regional politics, and what should Nigerians expect in 2027?
Let me first state this. Yes, let me first state this, that I'm not here to fan ethnic differences, but I have said, and I will restate here, that Nigeria has an Igbo problem. And this, of course, emanated historically from the Civil War, where we claim that it was no vanquished and no victor. But ultimately, there was a vanquished person. If you had 10 million naira before the war, you're giving 20 naira after the war. You are the one vanquished. If they said to you, you cannot be promoted in the army because you can't be trusted, you are the one vanquished. If you cannot get promoted within the civil service because you can't be trusted, you are the one vanquished. To come to your question, and just to say that anybody who says that an Igbo man is not treated differently is just lying. That's the truth. All of us know this. That's a big elephant in the room. And that is what I said earlier when I said, well, there's a Boko Haram guy who has been killing, beheading people, and he was sentenced to 20 years. And the guy who uses a microphone and a radio transmitter is sent to prison for life. They could have sentenced him to death if something hadn't taken place. Then to go to your question about the issue of how the regional power brokers behaved, I was in the midst of it. I was the one calling them off for protest. And I knew what I went through in the hands of the governors, House of Rep members, senators in the Southeast. They all flatly and vehemently, without speaking, refused to encourage their people to participate in anything that could peacefully. It was a peaceful protest planned. So who did we rely on? We relied on those in the markets to close down their markets. But the major leaders, including the deputy speaker, he came out shamelessly asking that the Igbos should sit at home and you should show that you are cowards. There's no cowardice in peaceful protest. The reason is that they believe that Nnamdi is too powerful politically, and that if he's released, he will have some impact on their political influence and popularity in the zone. They know that they are not popular, but they have all relied on the center to get whatever they want, to keep control over the southeastern political people. And they know that they are running out of time. If Nnamdi Kanu is released, that would not continue. We will no longer enjoy what they're enjoying now. Whatever it is, whether it is fake or real popularity or power, they will lose it. They know it. Because I will reveal to you today that one of the biggest issues with the Nigerian state and Nnamdi Kanu is that they couldn't get him to promise that he would renounce his agitation for Biafra. That's the biggest problem. That was his main crime. They said it. If they even proposed to me that I should go tell him to enter his defense, and if he enters his defense, then if they release him, he should promise that he will form a political party and participate in politics. And if he can do that, they will have no problem with him. He said, no, I want the Biafran, I want my region to be different from Nigeria because Nigeria cannot support our aspiration for greatness. Now, my caveat is that I am opposed to breaking up Nigeria. I'm a Pan-Africanist. But I have seen, read, and known that it is not a crime for people to seek self-determination. So the regional leaders we are talking about, I called all of them. I called all the governors. At least I know Soludo. I used to be able to reach him. I mentioned here that the governor of his state, Abia, was a columnist at Sahara Reporters. So I called a lot of them. No one of them picked my call. No one of them has called me back because what we want is not what they want. They want what they call a political solution. And a political solution is that you jail him first and then we'll beg you to free him on certain conditions. So that tag of less convict. They wanted it badly. All of them are agreed on that. The question is, how did they release him? Nobody can tell you when they will release him. They don't plan to release him because of his refusal to endorse their political agenda in the Southeast. That is the problem. They don't want to hear his name. But the people of the Southeast, the regular people, are in love with him. And we've seen that with what happened in protests, how markets were closed across the country without a whimper. And they still are going to fight to ensure that Nnamdi Kanu is free. I will still fight to ensure that Nnamdi Kanu is free from this unjust incarceration into which he's been thrown. And don't forget, and I'll say this in closing, that this is the same way Ken Saro-Wiwa was treated in 1995, this 2025. I guess every 20 years, or is it every 30 years, Nigeria needs a victim. Guess what? It happened in November 2025. Ken Saro-Wiwa was November 1995. 30 years later, the country hasn't learned its lessons.
There was a conviction recently of a terrorist, Boko Haram. I believe his name is Husseini Ismail. He was convicted for 20 years by a high court. He was a Boko Haram terrorist. Mazi Nnamdi Kanu was convicted, I think, last week, and his own conviction said life sentence. I don't understand why one terrorist is getting 20 years and the other is getting a life sentence if you're saying that. I think Pastor made a good point. There's this idea that justice is served differently, and it affects the problem.
I think Sowore have done justice to everything that we needed to say or we needed to talk about. Hello everyone, welcome back to this channel. Before we talk about this El-Rufai son, let's hint on the appeal court striking out Nnamdi Kanu's right suit. The news says the Court of Appeal has officially struck out the fundamental human rights violation suit filed by Mazi Nnamdi Kanu against the former Attorney General of the Federation, the Department of State Service, that is DSS boss, and several other federal agencies. According to the appellate court, the suit has now become academic, meaning a matter that no longer has practical use or relevance because circumstances have changed. Following Kanu's November 20th conviction for terrorism and his subsequent movement from the DSS detention to Sokoto prison facility, where he is currently serving a life sentence issued by the Federal High Court. According to the news, a 3-member panel of the Court of Appeal ruled that Kanu's allegation, including violation of his dignity, denial of quality health care, and restriction of his religious rights, could no longer be entertained since the conviction and new prison custody have overtaken the situation. Delivering the lead judgment, Justice Moses Ugo explained that the issue raised in the appeal lost their relevance the moment Nnamdi Kanu's counsel, Masol Okpara, confirmed in court that his client had already been transferred to Sokoto prison. The court stressed that since Kanu is no longer in DSS custody, it is legally impossible to grant a request asking that he is moved from DSS detention to Kuje prison. Justice Ugo also noted that Kanu had earlier expressed preference for staying in a proper prison facility instead of DSS custody, and now that he has been convicted and placed in that very environment, the relief he sought have been overtaken by events. Now, what does this judgment mean for Nnamdi Kanu's next step? Listen carefully. This ruling does not stop Kanu from challenging the main terrorism conviction or the life imprisonment sentence, because I see that a lot of people are getting emotional about the whole thing. This is to clarify you that it has no meaning to whatever judgment that was delivered on 20th November 2025. It only affects the specific right violation suit tied to his detention before conviction. To back this up, under the 1999 Nigerian Constitution, particularly Section 34, right to dignity, Section 35, right to liberty, Section 36, right to fair hearing, Section 46, right to seek redress for human rights violations, Kanu still retain the constitutional right to raise issues of extraordinary rendition, torture or inhuman treatment, denial of fair hearing, jurisdictional defects, or should I say questions, and prosecutorial misconduct. Whatever it is, he still have rights to actually, appeal in all of those rulings. Whatever the, trial court say about it, he has a right to seek for redress. Remember, I'm not a lawyer, but I'm just using whatever constitution we have in Nigeria. But when I'm using Nigerian Constitution to actually, give analysis on this. Now, in his appeal against the conviction itself, is the dismissal constitutional? Let's get this understood, because the courts in Nigeria, backed by multiple Supreme Court authorities, do not decide matters that have become moot, hypothetical, or academic. Is it unconstitutional to raise right issue after conviction? No, because right violation can still form part of the grounds of appeal against the conviction. So the dismissal only means the specific relief requested on can no longer be granted, not that the rights were never violated. You should understand this. Then, how does this very ruling relate to the earlier appeal court decision? This is where the controversy deepens. The same appeal court that once discharged and acquitted Nnamdi Kanu in 2022, we all remember, citing unlawful extraordinary rendition, has now dismissed his rights violation case. However, the earlier judgment was never overturned. It was only put on hold after the federal government immediately secured a stay of execution. But here's the funny thing. Yesterday's dismissal of Kanu's right violation suit does not in any way nullify that previous ruling. It merely reflects that the court is now treating all issues tied to his former detention as overtaken by event due to the new conviction. Talking about the comment of El-Rufai's son, why it is not advocacy but a subtle mockery, because I see a lot of people praising him. He's saying that he's actually advocating for Nnamdi Kanu and all of that, citing injustice and everything. That is not true. And let me break it down for you. During the lower house session, El-Rufai's son actually questioned why Nnamdi Kanu is sentenced for life imprisonment, whereas a Boko Haram terrorist just got only 20 years imprisonment. He cited that as injustice. This is El-Rufai's son comparing Nnamdi Kanu's sentence to that of another convicted terrorist. Now, this is what you have to understand in this very description of El-Rufai's son. He has just submitted that Nnamdi Kanu is another terrorist who got life imprisonment. Now, why many praised him for highlighting injustice, the underlying message is deeply problematic. And here is the issue. If you applaud his comment, you are indirectly accepting that Nnamdi Kanu is a terrorist, a label that he has not legally exhausted appeals against. Because whether you like it or not, seeking for self-determination is not a crime, no matter how you see it. Now, here's why this statement is a mockery to Mazi Nnamdi Kanu instead of what people perceive as a good advocate for injustice meted against him on the question of life sentence. First, it reinforces the terrorist label, which Kanu supporters reject because his case involves legal issue, not violent extremism. Secondly, it trivializes the self-determination struggle, reducing it to criminality. Thirdly, it redirects public perception, making it appear that Nnamdi Kanu's fight for self-determination is the same as acts of terrorism. Fourth, it suggests that Igbo agitation equals terrorism, which is a dangerous narrative, because whichever way you think about it, the Nnamdi Kanu's struggle is the Igbo nation struggle. And this is you criminalizing Nnamdi Kanu. And lastly, it paints Kanu as someone worse than a convicted terrorist, worse than that Boko Haram terrorist, by saying Nnamdi Kanu received a harsher sentence. So there are some sort of psychology in this very statement by El-Rufai's son. And that is what I'm trying to actually, dig at, so that people will know when their mind is being manipulated and when to actually direct their mind independently on public speech. Now, this is to back up what I'm talking about. Look at the tweet of Mazi Nnamdi Kanu's lawyer, one of his lawyers. He says, "Why commending Honorable Bello Elrufai for condemning the cruel and unusual penalty slammed on Mazi Nnamdi Kanu? Let it be clear that Nnamdi Kanu is not a terrorist, simply because the court labeled him as one. Mandela was also labeled a terrorist, but he triumphed, and Mazi Nnamdi Kanu also shall." This is somehow relating to my perspective about the stand of this El-Rufai son. So this is not an advocacy at all. It is a strategic political language disguised as a concern. Otherwise, you would ask yourself, is self-determination, like I said, is it a crime? It is not. Both Nigeria and international laws protect the right to self-determination. The African Charter protects it. The United Nations Charter protects it in Nigeria. Section 20 says people have the unquestionable right. They say unquestionable right to self-determination. Talking about the United Nations Charter, Article 1, Sub 2 says respect for equal rights and self-determination under Nigerian law, advocating for referendum, regional autonomy, restructuring, or peaceful separation is not a criminal offense. Let me sound this again so that people would understand, because I want you to be politically and legally, grounded when it comes to this Nnamdi Kanu's case. Because none of us, of course, we are not lawyers, but the case have actually, it has mandated us to go into knowing what the Nigerian Constitution means and the stance of its background. So the message is basically saying that, first, Nnamdi Kanu's case is bigger than the courts. It is now a national issue that touches justice, fairness, and Nigeria's political identity. Kanu's case should always be known to everybody. The Nigerian Constitution cannot justify the fate of Nnamdi Kanu because it is highly political and he is not alone. Now, secondly, the message is also saying that even though the appeal court dismissed one of the cases, that is the one the appeal court dismissed yesterday, the important issues like the question of extraordinary rendition, human rights, the jurisdictional question, and political interferences are still unresolved. It is also saying that the real fight is against Nnamdi Kanu's conviction. The case will shape how Nigeria will handle dissent and justice in future. Now, it's also saying that the story is not over. As always, this is about perspectives, your domain for unfiltered news and raw political analysis. Until next time, don't forget to like, share, and subscribe to the channel so you would always get notified each time we drop a new episode. Thank you for watching.